Glenn Mulcaire is being presented as the insider who refused to lie for Prince Harry. He says lawyers tried to manage his account, placed a prepared statement before him, and lost interest when he would not support the version they wanted. That is an explosive allegation, but the document that could test it has not been shown. The final high court judgment records something narrower and more important. Mulcaire never supplied a signed witness statement, never testified, and reached the case only through quotations in old journalistic articles. Harry later lost every claim, but the court did not find that he had lied. So was a whistleblower silenced, or was his evidence simply unable to prove where the information went? To answer that, the first task is to separate Glenn Mulcaire's history from the role the interview gives him in this particular case. Mulcaire was not an ordinary commentator looking back from the sidelines. He was a private investigator at the center of the News of the World phone hacking scandal. He admitted unlawful voicemail interception, went to prison, and later became a source of information in civil litigation involving press misconduct. His knowledge of the old newspaper world is real. His personal involvement is real. But experience with hacking at one publisher does not automatically prove unlawful activity by another publisher in every later case. The lawsuit at issue was brought by Prince Harry and 6 other claimants against associated newspapers, publisher of the Daily Mail, the Mail on Sunday, and Mail Online. They alleged that private information had been obtained through unlawful methods. The trial lasted 46 days, running from January to March of 2026. The judgment arrived in July. Every claim was dismissed because the court was not satisfied that the alleged unlawful information gathering had been proved for the specific articles and incidents before it. Their outcome is a major reputational blow for Harry, but the legal reason matters. Failure to prove a case is not the same as a finding that the claimant invented it. The rival interview moves quickly past that distinction. It frames Mulcaire as Harry's witness, then suggests he was removed because he refused to give false evidence. Yet the court record does not describe him as a witness who entered the box and changed his story. It says the material attributed to him was not contained in any witness statement, affidavit, or signed document. Instead, the court received quotations said to come from Mulcaire in 3 Byline Investigates articles published years earlier. Those quotations were journalistic hearsay. They were not verified by a statement of truth, and Mulcaire was not available for cross-examination about them. That is the first receipt the headline leaves out. The man sold as the missing courtroom bombshell never became a signed or testifying witness in the action. That does not prove his concerns were false. It limits what the court could safely do with them. A direct interview proves what Mulcaire now says happened. It does not prove that the proposed statement was dishonest, because the draft has not been published. It does not prove that Harry ordered anyone to pressure him, because no instruction from Harry has been produced. It does not prove that Buckingham Palace controlled the litigation, because no palace document appears in the record. Mulcaire's strongest point is still worth taking seriously. He says he wanted to give his own account in his own words. He says he was uncomfortable with the statement prepared for him and believed important context was being removed. Any potential witness should refuse to sign evidence that does not accurately reflect what he knows. If the unseen draft attributed facts to him that he could not support, his refusal would be responsible rather than obstructive. The difficulty is that viewers are being asked to decide what the draft did without seeing a single line of it. There is another possible explanation, and it is far less dramatic. Lawyers are not required to place every memory, suspicion, or historical grievance into a witness statement. They must connect the evidence to the allegations actually pleaded. Mulcaire repeatedly acknowledged in the interview that he could not always guarantee where information ultimately ended up. He might have been told that material was intended for the Daily Mail or Mail on Sunday, yet still lacked a reliable chain showing that the information reached those titles or produced a particular article. That uncertainty goes to the center of the legal case. A witness can possess a huge archive and still lack the one link a court needs. Thousands of documents may demonstrate how a newspaper culture operated, who knew whom, and what methods were available. They do not automatically prove that a specific journalist commissioned an unlawful act for a specific story. The claim that Mulcaire recovered 11,000 documents sounds devastating, but the interview does not provide an inventory, a sample, or a chain of custody. We do not know how many relate to Harry, how many concern associated newspapers, or how many merely document Mulcaire's wider career. This is where the court's reasoning becomes more important than the confidence of either side. The judge repeatedly distinguished private information from proof of unlawful sourcing. Harry could establish that a report concerned intimate relationships, personal movements, or conversations known to a small circle. That could make his suspicion understandable. It could also demonstrate genuine distress. But privacy alone could not prove whether the information came from voicemail interception, a paid source, a friend, observation in public, earlier reporting, or ordinary journalistic inquiry. The missing route between information and publication defeated claim after claim. The judgment also contains a fact that directly challenges the interview's moral verdict. Associated newspapers did not accuse Harry of dishonesty. The judge observed that Harry sometimes moved beyond factual evidence and began arguing his own case, something many emotionally invested litigants do. But the judge said this did not affect the quality of Harry's evidence, which he accepted. The problem was that Harry had limited direct evidence on the disputed sourcing questions. He could speak convincingly about what was private and why publication hurt. He could not personally prove how a reporter obtained every detail. That difference should not be softened. Harry lost. He did not win a symbolic victory, and the court did not accept that Associated had used the unlawful methods alleged for the articles in question. But he was not judicially exposed as a liar. The judgment did not find that he manufactured evidence or instructed lawyers to make Mulcaire commit perjury. Turning an evidential defeat into proof of personal corruption goes beyond the receipt. Royal receipts can be critical of Harry's case without inventing a finding the judge did not make. The most revealing twist is that the real private investigator witness crisis at trial centered on another man. Gavin Burrows, not Glenn Mulcaire, became the investigator whose changing accounts created a courtroom battle. The claimants had relied on earlier documents attributed to Burrows. They later obtained permission to call him as a witness under strict limits. During his evidence, Burrows denied that a key earlier statement was his, denied that the signature was his, and denied carrying out unlawful information gathering for Associated. The claimants then sought and obtained permission to treat their own witness as hostile. That episode is not a minor detail. It changes the entire mystery. The interview sells Mulcaire as the witness removed before he could expose the truth. The court record shows that Burrows was the investigator who actually testified, faced prior statements attributed to him, rejected those statements, and was questioned as a hostile witness. His evidence raised difficult questions about authorship, signatures, payments, preparation, and reliability. If viewers want to understand why the broader case struggled, the Burrows dispute is more legally significant than an unseen draft connected to Mulcaire. Burrows did not simply arrive and confirm the claimant's case. He denied that he had done unlawful work for Associated and denied providing information for specific articles involving claimants, including Elizabeth Hurley and Sadie Frost. He also denied authorship of documents on which the claimants had hoped to rely. The court then had to determine what previous statements could legally be used and what weight they deserved. This was an actual evidential crisis tested in court, not an allegation described later in an interview. The existence of the Burrows dispute does not prove every criticism made by Mulcaire. It does show why lawyers might be unusually cautious about investigator statements. Private investigators from the old tabloid world often operated through intermediaries, informal payments, recycled information, and records created long after events. Memories can be sincere while being incomplete. Documents can be attributed to a person who disputes their wording or signature. A legal team trying to convert that history into admissible evidence must distinguish what is known, what is remembered, what is inferred, and what can survive cross-examination. Mulcaire's own account contains the same tension. He says dark arts were used and information was traded. He also says he could not guarantee the final destination of some material. Both statements may be honest. Together, they explain why his history could be valuable, yet insufficient for this case. The court was not deciding whether phone hacking ever occurred in British journalism. That history is established. It was deciding whether Associated Newspapers was legally responsible for specific acts alleged in relation to specific publications. General knowledge of wrongdoing elsewhere could not fill every article-specific gap. The rival interview often turns these gaps into evidence of a conspiracy. When a meeting did not happen, that became proof Harry wanted plausible deniability. When Mulcaire did not testify, that became proof his evidence was too dangerous. When mainstream outlets did not tell his story, that became proof of palace censorship. When documents were not shown, their absence seemed to increase their power. This reasoning makes the claim impossible to test. Every missing receipt becomes confirmation of the allegation instead of a reason to reserve judgment. A more disciplined investigation asks what would change the verdict. The proposed Mulcaire statement would matter. Emails between Mulcaire, researchers, solicitors, and Harry's representatives would matter. A dated message showing that a lawyer knowingly inserted a false assertion would matter. Evidence that Harry reviewed and approved such wording would matter. None of those items appears in the interview. Until they do, the correct language is not that Mulcaire was asked to lie. It is that Mulcaire alleges a proposed account did not reflect the evidence he was willing to give. The same discipline applies to claims about palace involvement. Harry is the king's son, but Buckingham Palace was not the claimant, the defendant, or the judge. No instruction from the palace is produced. No member of the royal household is shown directing witnesses, drafting statements, controlling the trial, or prearranging the result. The suggestion that the palace scripted the case is especially difficult to reconcile with the outcome. Harry and every co-claimant lost. A system supposedly designed to guarantee his victory delivered a comprehensive defeat. That defeat should still be examined without triumphalism because several claimants described deeply personal harm. Elizabeth Hurley and Sadie Frost spoke about information involving relationships, family life, and private experiences becoming newspaper content. Baroness Lawrence brought her own allegations in the shadow of a public life shaped by grief and campaigning. The court could accept that information was private, that publication caused distress, and that concerns were sincerely held while still concluding that the unlawful source pathway had not been proved. For many women, that distinction will feel painfully familiar. Being believed about the impact of an intrusion is not the same as being able to prove who caused it. A woman may know that only a few people possessed a detail and still lack documents showing which person disclosed it. She may experience publication as a violation while a court requires a precise chain-linking source, investigator, journalist, and article. Losing that illegal argument does not make the distress imaginary. It means the evidence did not cross the required threshold. The public discussion often reduces all 7 claims to Harry's personality. That framing hides the separate experiences of the women involved and turns a complex privacy trial into another referendum on whether viewers like the Duke of Sussex. Harry's celebrity unquestionably drove attention. His history with the press gave the case emotional force, but the judgment had to consider each claimant, each article, each alleged method, and each source explanation separately. A broad belief that tabloids behaved badly in the past could not decide every individual allegation. The human cost also runs in the other direction. Journalists and former investigators were accused of serious unlawful conduct. Some allegations concerned events from decades earlier when notes were missing and memories had faded. A court cannot replace missing records with moral certainty simply because wrongdoing occurred elsewhere in the industry. Fairness requires the same rule for everyone. The accusation must be connected to the person, publisher, article, and method alleged. That burden can frustrate victims, but lowering it would create another kind of injustice. This is why the phrase whistleblower must be handled carefully. Mulcaire has genuine insider knowledge, and his willingness to speak deserves attention. But whistleblower status does not authenticate every conclusion drawn from his account. He is also a convicted participant with his own history, losses, disputes, and interest in how that history is remembered. His testimony should be checked against documents rather than accepted or rejected because of his character. The strongest part of his interview is the question it raises about the missing draft. The weakest part is the leap from that missing draft to a coordinated palace operation. The interviewer's questions repeatedly make that leap for him. Mulcaire says he was uncomfortable. The question becomes whether lawyers wanted false testimony. He says he was not introduced to Harry. The question becomes whether Harry deliberately avoided knowledge. He says the press and establishment protect their interests. The conclusion becomes that the result was scripted. Those are not neutral transitions. They convert uncertainty into accusation, then use agreement with the framing as though it were independent confirmation. The court record produces a more complicated portrait. Harry's suspicions were genuine. His evidence about privacy and distress was accepted. The wider history of phone hacking was undeniable. Some witnesses described unlawful methods used in the newspaper world. Yet the claimant still failed because the proof did not reliably connect those methods to the relevant associated articles. The case was not defeated by one missing man. It was defeated by repeated breaks in the chain between allegation and publication. Mulcaire's absence mattered within that wider picture. A signed statement would have fixed his wording, disclosed precisely what he claimed, and made him accountable to a statement of truth. Live testimony would have allowed both sides and the judge to test his memory, destination evidence, documents, and motives. Instead, the court had quotations filtered through journalistic articles. That is a weaker form of receipt. It cannot carry the same weight as evidence given directly and challenged openly. But it would also be wrong to claim that Mulcaire alone could have rescued Harry's case. His interview admit the central weakness. He could not always guarantee where information went. Even if he had proved that he intercepted a communication or passed material to an intermediary, the court would still need evidence connecting that act to associated and to a particular article. His testimony might have strengthened some allegations, damaged others, or exposed inconsistencies. We cannot know because the statement and documents remain unseen. One further detail matters. This was not a snap ruling after one hearing. The judgment followed 46 trial days and hundreds of pages examining witnesses, documents, notebooks, payments, source explanations, and disputed memories. That scale does not make the result infallible, but it makes the claim of a scripted outcome harder to sustain. Any challenge to it must answer the evidence, not replace it with suspicion. The final verdict, therefore, has 5 parts. It is proven that Mulcaire did not give a signed statement or testify in the trial. It is credibly reported through his own interview that he objected to the way a proposed account was being prepared. It is disputed whether that process represented improper pressure or ordinary legal efforts to remove unsupported claims. It remains unknown what Harry personally knew and what the draft actually said. The public headline exaggerated the dispute by presenting an allegation of witness pressure as proof that Harry asked someone to lie. The court's verdict on Harry must be equally precise. He lost all of his claims against Associated Newspapers. The judge accepted the quality of his evidence, but found that he had limited direct knowledge of the contested sourcing. His genuine concern about private information did not prove unlawful information gathering. Suspicion, however understandable, could not replace an article-specific evidential chain. That is a defeat in proof, not a judicial finding of dishonesty. The contrast with Gavin Burrows completes the story. Mulcaire was the investigator promoted outside court as the missing truth teller, but his material arrived only as hearsay. Burrows was the investigator who entered the witness process, rejected earlier statements attributed to him, was treated as hostile, and forced the court to confront the reliability of disputed documents directly. The wrong witness was sold as the bombshell. The actual courtroom crisis was more complicated, less convenient, and far more revealing. For the women whose private lives appeared in the case, that complexity should not become another reason to dismiss their experiences. Real pain can coexist with incomplete proof. A legal loss can reflect a weak source chain rather than an imaginary intrusion. At the same time, public sympathy cannot convert uncertain documents into reliable evidence. Royal receipts must hold both truths together. The claimants deserve to have their allegations heard. The people accused deserved findings based on evidence that could be tested. That is what the rival interview ultimately avoids. It begins with a verdict about Harry's character and uses Mulcaire's account to confirm it. A proper evidence investigation begins with the account, tests its legal status, compares it with the judgment, introduces the Burrows counter receipt, and only then reaches a conclusion. The conclusion is serious enough without embellishment. A potentially valuable insider never placed his evidence before the court in signed form, while the case failed across a broader pattern of missing links. The remaining question is not whether Glenn Mulcaire has stories. He clearly does. It is whether those stories can be converted into dated, authenticated, article-specific proof. If his draft statement and correspondence are published, the allegation of pressure can finally be examined. If his documents connect an unlawful act to Associated and a particular article, they could change how the history is understood. Until then, the record supports scrutiny, not certainty. Prince Harry's defeat is real. Mulcaire's accusation is real as an accusation. The missing statement is real. The claim that Harry requested false testimony is not proven. The palace conspiracy is not proven. The distress described by the claimants does not disappear because the legal case failed. And the court's demand for a reliable source chain does not become corruption merely because it produced an unpopular answer. So what matters more? The confidence of a former insider speaking after the event, or the absence of the signed evidence that would have allowed his account to be tested? Was Mulcaire excluded because he threatened the case, or did his uncertainty about where the information went make him impossible to use? And when a court accepts the pain but rejects the proof, should the public call that a cover-up, or the difficult line between suspicion and evidence?